Case on this morning's docket. Case number 114143, State of Kansas v. David S. Hankey.
May it please the court, I'm Ryan Enninger, appellant defender here on behalf of Mr. Hankey. If the court would grant me 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. This case comes before the court this morning after Mr. Hankey was convicted by a bench trial with stipulated facts, the District Court of Harvey County, of possession of methamphetamine, as well as a couple, I think 2 misdemeanor possessions of marijuana and a paraphernalia charge. The facts are that Mr. Thompson, or Officer Thompson, arrived at a Quick Trip gas station around 2 o'clock in the morning, found as he was parking his patrol vehicle, I think he drove through, saw a vehicle parked. Then he parked his patrol vehicle, got out, went to go into the Quick Trip gas station. Another individual there alerted him to the fact that Mr. Hankey was parked apparently in his vehicle and had been there for some time now, maybe 45 minutes, had bought a beverage, left the store, his car was still running, and he was apparently slumped over or asleep in the vehicle. Officer Thompson approached the vehicle, knocked on the window. Mr. Hankey immediately sat up. The officer then asked him, Mr. Hankey immediately sat up, and then he subsequently testified that his driver's door, his window didn't work, so he opened the vehicle. At that point, he struck Officer Thompson. Officer Thompson told him, "Do not hit me with your door," asked him to step out of the vehicle, asked him to produce his ID. He produced his driver's license, a warrant check, or Officer Thompson did not retain it to conduct a warrant check, but almost immediately handed it back to him and said, "Can I search the area where you're sitting?" That concluded in about a 3-minute time span. The district court found that this was that there was a valid public safety stop, which I don't think either of the parties are contesting, or not, public safety check, I should say. I don't think either of the parties are contesting that, but that the district court found that what occurred during that 3-minute span was a wholly voluntary encounter between Mr. Hankey and Officer Thompson. Therefore, that was not covered by any Fourth Amendment protections, and his consent to the search, which yielded the drugs, was valid and voluntarily given. The argument that I've made is that under the totality of the circumstances, made this argument at the Court of Appeals, under the totality of the circumstances test, what this really is a continually, very quickly escalating situation, which was coercive in nature. It was a show of authority by the officer, which would lead a reasonable person to believe that they're being detained under these circumstances for an investigation.
What was the testimony of the officer about when he began to suspect that Mr. Hankey was under the influence? Was it as he approached the car, or was it after he startled and opened his door, or did he say?
His testimony, what I recall is his testimony was that he rapped on the window, Mr. Hankey sat up quickly and immediately started to open the door. He then told him to step out. Well, "Don't hit me with your door." And then he said, "I need you to get out of the car." I don't know what exactly terminology, but he communicated the fact that you need to get out of the car. I think at that point, now this is only a 3-minute encounter, so I'm sorry.
Yeah, it's only a 3-minute interaction, so I just wanted to know what the officer said.
He said he seemed
about
disoriented. Like he woke up and was kind of, "What's going on?" More or less. So
as he approached the car, he didn't say, "I intended to have him get out"?
No.
That developed after the startle and the door.
Yeah, he did. There's no testimony. His only testimony as far as why he was approaching the car was to conduct a safety stop.
Right.
He was concerned that, okay, maybe this person's having a medical issue. I think was his testimony precisely was, I was concerned he had a medical issue.
And I'm a little unclear about the district judge's reasoning about whether it remained a public safety check or whether it converted to a voluntary encounter. Does it matter?
I don't think it matters.
Because you can have a voluntary consent during a public safety check as well as through a voluntary encounter.
And I don't think it matters for our analysis simply because what we're really focusing on is, I don't think Officer Thompson was doing what he should have done. when he approached the
When he
vehicle, and
checked
he
them.
was, perfectly within. And it's not. There's no Fourth Amendment concern or constitutional issues with him approaching to check on the welfare of a citizen. The issue becomes when Officer Thompson. He's struck by the vehicle, and I think the argument, it's one thing that's really important under the totality of the circumstances here is a reasonable person in that situation. I've just been awoken by a knock on my window. I've now struck the officer with my car door. He's told me to exit the vehicle, so now I'm out of the vehicle. Now he wants my identification. Here's my identification. Now he wants to search my car. And I think what I've argued and what I'm arguing today is that that's going to communicate to a reasonable person in that situation, a reasonable citizen, that I'm under investigation for something besides sleeping in my car. Or maybe I'm under investigation for, can I sleep in my car? That's, I think, one of the fundamental flaws with the way the way this was conducted. There was no communication between the officer and the citizen as far as, sir, I'm here to check on your welfare. Are you okay? There's no evidence whatsoever that he was even asked, are you okay? So I think as far as the relevance of the public safety stop, that probably is the one thing that is important about it. Is he was never even asked, hey, are you okay? Or I'm here to. He was never informed of what this was about. He didn't say, hey, you can't sleep here or anything along those lines. Mr. Hankey was never informed of what the purpose of this stop was, why he was being questioned. It was simply a rapid fire and escalation from get out of the car, can I search your car? There's no disengagement between, okay, I've returned your license. I mean, that goes even further. There's no information of why I've stopped you. I'm checking on you. Then there's no further, here's your license back. May I ask you a few more questions? There's nothing along that line. And so my argument is that Mr. Hankey was simply quick, very rapidly, and any reasonable person in that situation is going to feel a coercive environment, and is the consent given. I'm sorry, Jim.
The officer conducted the public welfare check partly because he had been informed that Mr. Hankey had been there for some time, like an hour or something, right?
Correct. I'm
and
sorry.
so you have a person that's slumped over a steering wheel in front of a convenience store for over an hour, assuming that there's some traffic in and out, and that's not really a place that's conducive for napping.
Correct.
That what suspicion does that give rise to legitimately in this officer?
Well, I don't think it's. All I can point to is Officer Thompson's testimony, and his testimony was not, I approached the vehicle thinking maybe there's an issue, or that he had any information. It wasn't though somebody in the convenience store said, hey, that guy came in and he was stumbling on his way to the Coke machine and stumbled his way out, and now he's been sleeping in the car. The only information in Mr. Thompson's testimony was that, hey, somebody told me that he looked like he'd been sleeping there. He'd been there for about 45 minutes. How long he'd been sleeping, I'm not sure. But he said, I was concerned. I wanted to make sure he was okay. And he did not communicate any information that the officer would have received from anyone indicating that Mr. Hankey was impaired. He even testified that there's no smell of alcohol. There's no odor of any illicit drugs or anything like that in the vehicle. The only thing that he pointed to was that Mr. Hankey seemed somewhat disoriented when he woke him up by knocking on the window, all within a 3-minute span.
Why doesn't the officer's request to get out of the van and produce the ID, etc., why isn't that just totally consistent with a wellness check? You want to see if somebody's motor functions, if they have balance, not because of an impairment, but perhaps an illness or a stroke in progress or who knows what. That seems very reasonable to me to say you're checking on somebody's wellness and you just want to...
I agree, Judge. I just think it's reasonable for the officer, I think, from that standpoint, but that was never communicated to Mr. Hankey. So a reasonable person in his situation isn't going to understand, I'm being asked to ID myself. I'm being asked to, as I wasn't asked for anything other than to get out of the car. I was given commands. Don't hit me with the door. Get out of the car. Give me your license. There was no, I'm sorry.
Is your argument that the consent was involuntary on the one hand, or is it that is your argument what I read Judge Atchison to be suggesting in his dissent, which is that the check turned into an illegal detention?
Yes.
And that it was the illegal detention which tainted the consent. That's different from the consent was not voluntary, right?
Well, I think it's kind of a twofold argument. I mean, if on the one hand, if the court's going to go down the road that we had an investigatory detention, then I've argued that it was not supported by reasonable suspicion, and therefore it's an illegal detention, and the consent would then be involuntary. It could be that the taint wasn't attenuated substantially enough to clean the slate.
That's what I understood your argument to be.
Right, but then I'd agree with Judge Aston that we can get there two ways, and I think both are correct. The question of, was there ever an investigatory detention? I think so. I mean, I've argued yes, and the taint was not. I mean, it's a 3-minute encounter, so that is the exact argument that I've made in the brief. But I think in either situation, we get to the suppression of the evidence. Unless the court has additional questions for me, I think I pretty much covered the points I need to, and I would yield the remainder of my time.
Any more questions? Thank you, counsel.
May it please the court, Jason Lane from Harvey County appears for the state. There's nothing in the facts of this case to show that Sergeant Thompson acted with any coercion towards Mr. Hankey. This started off as a concern for a citizen who's been reported slumped behind a wheel of a vehicle that's been running for an hour in a public parking lot in a busy area of Newton, Kansas. This was a voluntary encounter from the very inception to the request and reception of consent to search.
What do you make of the fact that that concern was never communicated to Mr. Hankey? There was no, are you okay? Are you sick? Are you having an event of some sort?
I would disagree because the record does show that Sergeant Thompson, he stated during the examination, I asked him if he would step from the van, which he did. He was having difficulty fixating. I asked if he was okay.
After he exited.
Yes, after he exited, but before he asked for consent to search.
But that's where I have a problem, is if you believe someone's having a cerebral or a cardiac event in the vehicle, why would you have them exit before you ascertain that they were okay and able to do so? You understand what I'm saying? Is something might be wrong with him. Okay, well, get out of the car here and close the door, and we'll check you over. I mean, it's kind of contradicts that welfare concern when he tells him immediately to get out of the car.
And I think the answer to that is, how was Sergeant Thompson going to communicate with Mr. Hankey? The facts of the case bear that when he knocked on the window, Mr. Hankey was startled and opened the door into him, thus showing an indication that Mr. Hankey was exiting the vehicle before he even realized the officer was present. Mr. Hankey's testimony was the window was broken, so there was no way to communicate at that point. And Sergeant Thompson clearly said, don't hit me with the door, just roll down the window. It's not a command. It's just, I want to talk to you, roll down the window. You don't have to get out. That was clear. He just wanted them to roll down the window. But the window's broken, they can't have that conversation. So he says, please get out of the car, or will you get out of the car? It's not a command to get out of the car. It's, hey, I'm checking on you. I want to communicate with you. Will you get out of the vehicle so we can talk? Because we can't communicate through the window. And that brings me to the point that Judge Atchison says a reasonable person who just hit an officer with a car door no longer feels free to terminate the encounter or leave the scene because of the fear of being arrested at the end of the incident or being issued a citation. This is a common fallacy with the reasonable person standard because we create these reasonable people in our minds. And in this case, it's clear that we created a reasonable person with severe anxiety in the presence of law enforcement officers. The reasonable person doesn't have severe anxiety and believe every action they take might be scrutinized for criminal activity. They would know that if they were just startled, they opened the door and hit the officer, it was an accident. That there was no intention to commit a crime here. In the reality of the situation, if you ask any law enforcement officer, if you believe someone intentionally hit you with a car, do you wait around? Do you issue a citation later? Absolutely not. You pull the person out of the car, you subdue them to avoid further injury to yourself or further attacks upon yourself. Because that's the point of an intentional act. The reasonable person knows this. They know an officer is going to stop any intentional acts of violence towards them. But that's not what Sergeant Thompson did. He said, don't hit me with the door, just roll down your window. An indication, I just want to talk. So the reasonable person at this point doesn't feel fear of being arrested or to terminate the encounter. And I think we get muddied up because in the district court level, the defense argued this is like the Thompson case, the colloquial Columbo maneuver or Turnpike two-step. It's also considered, maybe if we look at State v. Neighbors and the emergency doctrine, those cases deal with the taint of the consent based on illegal detention. But the predicate of those cases is there was an initial detention or seizure. There was no initial seizure in this case. The precedent is clear. The mere walking up to an individual on the street, positing questions by an officer, does not create a seizure. And that's what happened here. And there were 3 questions. It was, let me go back. Essentially, please get out of the car. Do you have any identification? And may I search your vehicle in the area you were sitting?
When did the "Are you okay"? When did that fit into that sequence?
Okay. It was the don't hit me with the car or door, just roll down the window. I asked him if he would step from the van. Then I asked, is everything okay? And he was slow to respond and said no. And then he asked, do you have any identification? So it happened between asking him to step from the vehicle and asking for his identification to see who he was talking to.
Right when he first got out of the car, basically. Right when he first got out. Is
Right.
when he asked him, yeah.
And a 3-minute stop in totality, it had to be pretty quick to
Yeah.
ask, are you okay?
Back to back, basically.
And the other thing that muddies it up is the defendant's testimony is, I don't really recall what happened here. So we have to go on what the district court found for the facts on this case. You asked about the voluntariness of the consent. And this has to be, did an illegal detention taint voluntariness? Your precedent has said that we look towards an abuse of discretion, or whether, not abuse of discretion, whether substantial competent evidence supports the findings of the district court on voluntariness of a consent.
Yeah, there's nothing that would suggest a coerced consent, assuming that the contact was voluntary, or assuming that there wasn't a detention. I mean, there's nothing. You could have a circumstance where there was no illegal detention, but then consent is coerced,
Right.
by some other means, and that's not in the record. That's my understanding, at least.
Absolutely. The issue about asking for identification was raised on the appellate court level. It's not really argued here anymore. It's really, let's talk about the door incident. But I think it's important that merely asking for identification does not create a seizure in itself. It just sees who the person is. Now, the retention would play a factor in that analysis of whether this was a voluntary encounter. I do want to mention that consent is favored by our courts, by our justice system. It's probably the next best thing to a search warrant. It's the exception that courts want officers using if they don't seek a warrant. Ask. See if they'll give you consent. And that's what happened here. I argued in the alternative, and I think you mentioned a little bit, what was the suspicions of the officer during this investigation? And one thing that strikes us in these public safety or welfare checks or even stops is a lot of times, if it has to do with motor vehicle, there's a dual purpose there. Because unlike neighbors where it's a residence and there's no crime to be intoxicating your residence, it is a crime to drive under the influence to a degree you can't operate that vehicle. And when you walk up to a vehicle where there's a person slumped over that's been there for an hour, you're thinking two things. Is there a medical issue, or is this person intoxicated? And that's what was going through the officer's head. And that's what a reasonable officer would think when they walked up to the scene. So when he's talking to Mr. Hankey, he does ask, "Are you okay?" And Mr. Hankey doesn't indicate any medical problems whatsoever, doesn't say he's injured or having any mental health problems. So we start eliminating the one issue, but we're starting to see signs of the other. Well, he's slow to wake up, he's startled, he opens the door when he says he's trying to roll down the window. He's disoriented, he's looking around a lot, so Officer Thompson asks him to step out. Are these articulable facts? They are. The officer's experience, someone in that position who's done DUI investigations, who has eliminated any reasonable cause to believe there's alcohol intoxication, but knows about drug intoxication. And he starts investigating on that point. So I think the purpose here is, even if at some point...
Aren't those arguments inconsistent? I mean, first you say there was no investigatory detention, and in the alternative there was.
Well, I don't think they're counter.
Well, you can't be both.
My sole position is voluntary. But, as we've seen in the appellate court level, opinions differ.
There was nothing below that would indicate from the testimony that the officer was proceeding on what he believed to be reasonable suspicion, was there?
Well, we don't care what the officer subjectively believed when he was...
You mean if the officer testifies, I had no suspicions whatsoever,
Well,
that an appellate court could look at it later and say, well, we can look at the facts and say that reasonable suspicion still existed?
Absolutely. Because the Fourth Amendment is an individual protection and has nothing to do with the subjective beliefs of a law enforcement officer. So even if the officer says...
Usually that works the other way around.
It does.
Where we say, if the officer subjectively believes he has suspicion, we will reserve the right to objectively review that belief. But
Right.
here we have an officer saying, I didn't suspect anything.
Yeah, but I disagree with that too here, because Sergeant Thompson did say, I was investigating, I had suspicion that he may be impaired by a controlled substance. And he put all the factors, and he talked about how normally someone's not asleep in the middle of Newton, unlike a truck stop. He put forth that usually when they're just lightly sleeping, they'll wake up pretty fast, but not here. He was drowsy. He was looking around. So the record does indicate the Sergeant Thompson was looking for signs and seeing signs to create reasonable suspicion of DUI. And I think he did present enough facts. So although the district court and this was a mischaracterization or quote by myself and the district court judge. We said probable cause. I think the context was clear. We are talking about reasonable suspicion and whether the request for consent was in the scope of that formed reasonable suspicion.
Counsel, could you address an issue for me? The district court called this voluntary throughout. Is that correct?
Yes,
And I think the Court of Appeals basically said the same thing.
correct.
The public welfare or safety check, does it really put it in terms of this is voluntary on part of the citizen, or does it instead say this is simply an authorized detention and there's no Fourth Amendment issue?
Well, I think where we start to veer off is we call it a welfare check or a public safety check, but a check is not a seizure. So the exception you're referencing would be a public safety stop or a stop for the check of the welfare where there is an actual seizure. Because if there's a seizure, there has to be exception to the warrant requirement, and that exception is a public safety or community caretaking interest. A check, on the other hand, like in this case, there is no seizure. There's no stop. There's simply an interaction between a law enforcement officer and an individual. So the public welfare check would be a voluntary encounter because there is no seizure. I'm asking the court to find that this was a voluntary encounter, that the consent was validly given without any taint of an illegal detention. Thank you very much.
Before you sit down, counsel, we may have some questions.
Sorry.
I do. I'm going back over the summary of his the officer's testimony, and he indicated because of his observations, he suspected Hankey might be under the influence, and then asked him to step out of the van to talk a little bit more. That sounds like we have a investigatory scenario going on at that point. If he's asking him to get out, not to check about his welfare, but to check as to whether he's under the influence of illegal substances.
And again, an investigative scenario is not a seizure. And the officer's subjective beliefs, intents, and ideas at that point were communicated to Mr. Hankey. And therefore, a reasonable person without that knowledge of the officer's subjective beliefs would not believe this was anything more than a voluntary encounter. And it goes back to this is a check and not a stop or seizure.
Any more questions? Thank you, counsel.
I don't think I have a lot to add if the court has specific questions for me.
Is any interaction between a law enforcement officer and a citizen on a wellness check, welfare check, create the concerns that it is a detention? It automatically becomes a detention because there's that interaction.
No, I don't
I mean,
think
what's
so.
the difference? And the difference here is pretty subtle, I think. I mean, we have bumping into the car door maybe creates some apprehension.
Oh, and there's we get out of the vehicle. Can you
Get out of
your
the vehicle.
license?
But yeah.
I would argue that most.
Isn't there some, by basis of an interaction on a wellness check, there'll be some
There's a brief.
some implication of I don't want to go as far as coercion, but some implication that there's kind of a power discrepancy or something like that. It's not an ordinary encounter of some stranger kind of saying, "How you doing? Are you doing all right?" It's a law enforcement officer, and what's the difference?
I don't know if I completely understand your question.
Well, my question is, I guess, is that just by virtue of having the interaction on a welfare check, does it automatically create the
seizure?
scenario that you're complaining about?
No, I don't think so. I think I think an officer can approach somebody in a public place at any time and say, if there's some basis for, in this case, somebody says, hey, you might want to check on that person. They might need help. Well, then that creates a part of the officer's public duty is to check on the welfare of a citizen. And I don't think that every time an officer contacts a citizen, you're not necessarily implicating the Fourth Amendment.
When we talk about investigatory detention, we say that the duration and scope of the inquiry and the investigation has to match the situation for which you had reasonable suspicion. And it would seem to me that same thing should apply to a welfare check. If you have some concerns about a citizen's welfare, once you dispel those concerns, that should end the encounter.
Exactly.
And when here would you say that objectively the officer's welfare concerns were dispelled?
I would say they were dispelled when Mr. Hankey sat up and began speaking with them. And I think if you review the officer's testimony, there does seem to be some implication of that he was no longer concerned, or at least, the very least, and that's what's kind of difficult about this is because Mr. Hankey strikes him at the door, and I know he didn't smash him with the door, but he struck him with the door. He touched an officer with the door. Most citizens feel unnerved by that, yes. I think that's a reasonable, but I think then when he tells him, don't hit me with the door, just roll down your window. Well, okay, but now get out of the car. Well, now he doesn't want to just talk about rolling down the, want me to roll down the window and talk. Now he wants me out of the car. This is a little different. And then I think, as the state indicated, he did say something to the effect of once he had him out of the vehicle and his license, you all right? So I think the concerns, and I think, I would agree with Judge Ashton's opinion when he says his concerns for his welfare evaporated when he sat up and began communicating with him. Does that answer your question?
Yeah, I think so. But this officer did seem to make an effort to dispel coercion when he, after getting the license plate, pulled the patrol car over to the other side of the parking lot. So it's not to block, had no lights on, no emergency lights or whatever, and walked over a foot. He testified he did that so that the occupant wouldn't feel like they were boxed in or whatever. So he made a Herculean effort to make this look like to the occupant, make it look like a welfare check.
Correct, and I think the argument I would make is that it could certainly be more coercive. We could certainly he could have pulled behind, and I think his effort there was, let's make sure that I don't go up, or I don't go before the district court, and I've clearly seized this individual. If he said I wanted to make a welfare check, that was his initial purpose, I'd say he did everything appropriately. And I would argue that certainly it could have been more coercive, but that does not mean that a reasonable person in this situation, based on these objective facts, would not have reasonably felt the pressure and the authority of state authority and coerced with a quick succession of events to thinking this is how this culminates, is I give consent and here we go. And not felt free to disengage and say, okay, I'm fine. Leave me alone.
Can the obtaining of identification be consistent with a welfare check?
I think it depends on the specific facts of the situation, like so many of these cases do. If somebody seems disoriented, doesn't know who they are or what they are or what's going on, then maybe I need to see your identification so I can determine whether or not you are in need of medical attention. In this situation, I don't think there was anything that really necessitated the taking of the license from the defendant. He knocked on the window, he sat up.
It's certainly understandable when he ran the tag and the vehicle came back.
Registered to a different individual. Yeah. Absolutely. Unless the court has any additional questions for me, we just ask that the evidence be suppressed and the conviction reversed.
Any more questions? Thank you, counsel. Thank both of you for your arguments this morning. The court will take this matter under advisement.